Welcome to Remembering Civility During Client Interactions, a guide for personal injury lawyers. I'm Neil Wall, Vice Chair of BHBA's Barrister Section, and I'm delighted to introduce our speaker, Eric Traut. Eric V. Traut is the founding partner of Traut Injury Law and one of the top trial attorneys in Southern California. He distinguished himself early in his career as the youngest recipient of the Orange County Trial Lawyer Association's Trial Lawyer of the Year Award in 2003 and received it again in 2023. Recently, he was selected by the 9 chapters of Calaboda as their Trial Lawyer of the Year 2024, which is the highest honor for a trial lawyer to receive in California. In his 35 years of practicing law, Eric has successfully tried over 100 jury trials. Eric's reputation for civility, ethics, and fair play precedes him. Judges, arbitrators, and mediators alike have openly admired his integrity, compassion for his clients, impressive trial skills, and his gift of advocacy. And now, let's get started.
Well, good afternoon, everyone. Thank you for joining me, and especially in a very timely topic in today's world. We're going to be talking about civility during client interactions specifically, so sort of a real direct content discussion today, but I will say it's timely in that our country is so divided. There's a lot of incivility that we see on a daily basis, not just in our own law practices, but across this nation. So talking about and getting a refresher on civility, I think, is a big deal. And that's why I decided to present this topic to all of you today. One of the things that we didn't learn in law school is how the importance of being civil as a lawyer. And that includes, obviously, our conduct with the courts, opposing counsel, but even on a bigger scale with our clients, because our clients are the ones, obviously, we were representing and we want to do the best for. And so imparting our civility often is helpful in their conduct and how they conduct themselves during litigation, during depositions. And so let's talk about remembering civility during client interactions and the importance of it. And I always like to provide some tips to folks that are helpful in their own practice, maybe things that they haven't thought about before that are helpful in preparing their clients for either depositions or trials. And because I've conducted over 100 civil jury trials, all in wrongful death and injury cases, and prepped many, many more clients for their depositions, I think I have a pretty good handle on what works and what doesn't, particularly when you have clients with varying personalities, varying characteristics that can play a role in how the jury, the judge, opposing counsel looks at them. But one of the most important things that they have to keep tamped down is their anger. They're upset with the situation. They're upset with being in litigation, and you have to help them in that regard. So let me give you some practical tips. First of all, we all know, for those folks who are involved in personal injury litigation, that people, especially in catastrophic injuries, are dealing with grief. They're dealing with anger, being put into that situation, a lot of times financial strain. So by the time they come to us as their lawyer, they're not just looking for a lawyer to do a good job for them. They're going to need somebody who can counsel them because, of course, we are considered counselors at law. And in these sorts of cases that I handle, it's a big part of your first interactions with your clients. Patience is a biggie, compassion, having a civil tone in supporting them. The first meeting is very important. I'm not one of those lawyers who has an investigator go out and sign up a client or has a paralegal sign up a client. I want to get a feel for who they are, if it's the right type of case for me, and to set the tone when it comes to civility. Because when I meet with someone for the first time, as many of you have experienced, you may have a client who is one of those people who wants a pound of flesh. They come in asking for the bulldog. They come in wanting things other than the compensation that you're going to get them at the end of the case. Maybe they want that too, but they also want that pound of flesh. And I let them know from the outset that is not my role. That is not what has worked for me for 35 years. I can be a strong advocate for you, and I will be, but I'm not going to sacrifice civility in the process. And I explained to them why in 35 years, acting civil with even claims adjusters, not just lawyers, has proven to be a big success and why I get things done and why I can help maximize the recovery for my clients. Obviously, trying cases helps because you get that reputation, but you also can garner a very good reputation with opposing counsel in what is a relatively small community. Whether you're in LA or Orange County, you're likely going to see that defense counsel again in my situation. And so you want them to come back to the table knowing that you're going to deal with them in a nice manner. You're going to be a zealous advocate, but they're not going to have any troubles with you throwing up roadblocks or having personality conflicts with you. So I tell those clients in that first meeting, um, you have to remind them also, if they're angry about their situation, to be careful about what they post on social media. I tell them it's important that you know that the defense is going to see what you post and sometimes can use that. If it's impeachment, of course, they definitely could use it, but we've all seen the surveillance that's been done and the investigation that has been done by insurance companies on social media. I had a case last year that's since resolved that the defense lawyer gave me a report that a private investigation company that specializes in social media investigation gave them, and it was almost 1,000 pages and super detailed. And I was impressed with how deep they went. Nothing really significant that affected the case, but boy, did they do a great job at researching everything this person had ever posted. So when you first meet with the client, of course, you can't tell them to take down stuff that they've already put up on social media. It's an ethical violation to do that. But moving forward, you can tell them to be careful about what they post, and particularly stuff that involves anger. If it's a drunk driving case, or if it's an assault case or a sexual assault case, they have to be extremely careful and know that everything they post is going to be seen by the other side. I also remind them on the civility side of things that during their treatment, that they make no inflammatory statements or send caustic emails to their healthcare providers or their employers, because as you all know, that stuff is discoverable. And I don't want that medical record popping in to a deposition or a trial where they've attacked something that the doctor's done, or they've argued about the type of treatment that's being rendered. So people are more apt, as we all know, to be more inflammatory in emails or during Zoom meetings than they are face to face or in person or on the phone. So they have to be very careful about sending things to their healthcare providers and to their employers, and I tell them right at the start. Um, let's move on and talk a little bit about preparation. And because in several instances, you're going to be preparing those clients for statements under oath, to be deposed. And as you can imagine, this is one of the most important times to spend a lot of time preparing a client. I know when I first started practicing law, I thought that a half hour to 45 minutes might be enough to prepare a client for their deposition. And I soon learned within a year or two that that was not the case, particularly with folks who have personality issues or come into the case very angry, and that you're going to have to spend some of that time counseling them on how to conduct themselves, particularly now with Zoom depositions and a lot of videotaping being done of depositions. It's even more important that they maintain their civility during the deposition. So I spend a lot more time preparing them. You may also have reason to prepare them if their testimony will relate to prior medical conditions that they have. And a lot of times either people forget or don't forget and just don't tell you about them, and you see it in medical records. And if you do, you're going to have to spend a lot of time with them prior to the deposition so that when they get that medical record or whatever document it is that's thrown in front of them, that they don't lose their composure because now they've already seen it and talked about it with you. Um, but the same is true with police reports and statements made to police officers. Sometimes our clients say, well, I didn't say that, or I didn't say it that way. So you have to spend some time so they're not pit up against important witnesses, in your case, a treating doctor or a police officer, and you can walk them through their testimony so that they're not attacking those folks on the record. Obviously, you want to instruct them to answer clearly, truthfully, but really, really important to tell them this deposition is not the time to tell their story. I don't want them vomiting up every fact, he said, she said story about the collision, about every communication that they've had with the doctor, and their whole to the beginning of their life until this point story about how it's affected their life. I tell them this is an important time to give a more of a Reader's Digest version of events, and don't feel like you have to keep offering information to tell your whole story. Your whole story should be told at least by you and others at the time of trial, and not in a 4 or 5 hour deposition. And I think the best way to tell them about not losing their composure, not telling their whole story, is to say, look, would you rather have a 2 hour deposition or a 4 or 5 hour deposition? And that will change their attitude and their approach much faster than just giving them these ideas. If they know this is going to be less time on the hot seat, they're more apt to listen to you if they're one of these folks who's a rambler. You're all going to know in a first meeting with somebody, even 15, 20 minutes, whether they're rambling type or not. And I will put that in my client interview notes if I realize that, if I've had a Zoom meeting with them or an in-person meeting where I know that they just want to spill their guts about everything. I put that in my notes so that when the time comes at a statement under oath or at a deposition, I review my notes and I know, okay, I got Susie Rambler here. I have to focus on that a little bit more than I would with most folks. Um, the other thing that plaintiffs don't know in injury cases is that over complaining is a detriment to their case. Exaggerating is a detriment to their case. It's counterintuitive to some folks because they think, hey, the more I tell this other side that how my life's been affected and turned upside down, and I really emphasize my pain was a 10 out of 10 every day for 6 months, that means the value of my case goes up. I'll get more compensation. And I know particularly from trials, that that is not the case. The best results I've had, the best 7-figure results in trial up and down the state, have been those clients who don't get on the stand and complain, those clients who don't get up on the stand and exhibit anger or animosity. I actually have them and really promote optimism. They can be realistic in their description of their injuries and how it's affected their life. Of course, I tell them you don't have to downplay things, but your general damages are generally going to come from other witnesses in your life. And so um, the last trial, I can just give you an example where someone who was very stoic but with a bad injury did well. My last question to her on the stand was, how are you feeling about your future? Tell the jury how you're feeling. And her response was, I'm optimistic. My work is letting me work from home, and I appreciate that. My family lives nearby. They come over. We go out as much as we can. They give me a lot of support. So I'm not letting this situation get me down. I'm moving forward with my life, and I'm optimistic about the future. That's generally what she said in about 5 minutes. And the jury rewarded her with a very good result. And it's because the other testimony about how bad this really was in limiting this injury came from other folks, came from the doctor, came from her daughter, came from her mom. So they need to know this at the deposition phase. They need to know that it's okay to be optimistic and to let the other side know, I don't like going to doctors. This has been a struggle for me. I'd rather just, not do that. I'm dealing with the pain as best I can. I'm trying not to let it limit my activities. So that's a big area, and I know that works because jurors don't want to feel like they're the plaintiff is tugging on their heartstrings as much as this plaintiff is trying to get back on their feet and do their best to get their life together. So make sure they don't exaggerate. Make sure that they don't guess. Make sure that they don't argue with opposing counsel. I'll give you one example that came up a few years ago in a case where I was sitting next to my client. I gave her the whole prep time that I needed to. And a question came up from the defense counsel, which was very generic in my opinion, which was, where did you graduate from high school? Seems pretty innocuous, right? Well, the client looks at me and says, do I have to answer that? Literally turns in her chair. Do I have to answer that? So I said, let's take a break. Let's go outside and see I don't understand what's going on here. So her perception was that because she had not graduated from high school, that the defense attorney was bringing this up to make her feel less, to make her feel bad that she never graduated from high school. She just read into the question. And I told her, he's not doing that. He's just trying to get some background out of the way, and don't let it affect you in that way. Most lawyers are not going to do that and try and make you feel less because you didn't go to high school. So you just never know where things are going to come from and what's going to cause some anger. But make sure that you stop the deposition. Obviously, in most instances, they're going to have to answer that question before you take a break. That's usually what the defense attorney is going to require. Sometimes they don't, but take them out, calm them down, and let them know, you just can't do that. If also it's being videotaped, which a lot of times we're seeing now, of course, tell them to be careful of their facial expressions. If they just start expressing sarcasm in their face or anger, that's going to show on the video. That good defense attorney is going to try and get some clips of that in at the time of trial on cross or an opening or closing. The other thing that's important in preparing them for deposition is if they have some anger towards one of their physicians for some reason, talk to them about that. See if you can tamp that down. Sometimes, as some of you have experienced, your client will be shown a medical document that has an alleged statement made by the client. And we all know that doctors don't always get those right. They're not painstakingly making sure everything they write down about that history, every sentence is perfectly accurate. They're just there to fix that client, treat them, make a diagnosis, and move on. Not so much worry about causation, and so they sometimes just don't get the facts right. So you got to make sure you let the client know, don't just agree with a statement in a medical record. If you don't remember saying that, or you don't think you said it, that's okay to say. Don't object and angrily disagree with it in most instances, because it's typically just a doctor who's just got it wrong. But let the defense attorney know that you don't agree with what it says, that you either didn't say it or you don't remember saying it. Eventually, at the end of a deposition, the civility that your client exhibits really assists them in their credibility and their claims. Ultimately, it helps jurors too, and judges see them as reasonable, relatable, trustworthy, more likable, which is really what we need to have happen if we're going to end up trying this case. Let's go ahead and take a quick look at an unprepared client. And I'll just have a couple comments afterwards. This is the only video I'm going to be showing you today, but I think it's an extreme example, but it happens.
Okay. Mr. Patel, do you recall hiring a tenant from the Heartland Hotel to clean or do work at the sea captain?
No. Sea captain?
Yes.
Why are you talking sea captain?
No, she's asking about whether
Just
you...
talk for Heartland Hotel. Don't go to
She is.
other property.
She is.
Okay?
She is.
Careful.
I will...
Much careful for my other property. You wanted to know about Heartland Hotel? That's all. Take it easy.
If Raymond were...
You don't pay the academic copper cent for my property. What you talking about, sea captain?
Raymond, you want to take a break?
No, I don't want to take it. She don't want to talk my other property or for my wife or my children or any other businesses.
You
Who are she?
Raymond, do you want to take a break? Shall
No,
we
I
stand
don't want
up?
to break.
Okay.
She's
Are you ready?
start to brainwash me.
No, she's not.
Watch it. Why people kill people? God it.
Raymond? Raymond?
Can I have that last piece read back?
Go ahead.
Raymond?
Can I have that last part
Are
read
you...
back?
Are you
Why
ready?
she born over here? To eat other people's head? What you want from Hotel Hotel?
We're going to take a short
She
break.
don't know your client yet. She liar. Number one liar. In San Francisco, I've never seen like you, woman.
going off the
This
record.
city.
We're going to take a break.
No, I don't want to break. I want to go home.
Well, you can't go home until
Sea
we're done.
Captain, Raymond Hotel, Industrial Hotel.
Come on.
What you talking about?
Come on. Come
Who
on.
are you?
Come on.
From my property.
Come on. Come on.
Huh?
Going out
You
the
didn't
door.
pay 1 copper cent on me.
We're going out the door. Come on.
So that's an extreme example, obviously, but as you can see, that lawyer waited way too long to suspend that deposition to calm his client down, literally having to wheel him. Ultimately, I cut this off at the point, but he eventually wheels him out of the room, and it should have happened a lot sooner than that. Obviously, his videotape, he was very caustic and mad just about a couple words that were said. And the lawyer may or may not have seen that coming, but he obviously didn't prep him well about controlling his anger. So if that happens, he should have been taken outside and talked to 10, 15 seconds into it. As soon as you see that frustration and that anger coming out, it's time to suspend that deposition. All right, let's switch gears here and talk about, we've talked a little bit about interacting with doctors and experts, but you're going to have your clients obviously involved with experts on both sides, doctors on both sides. But the medical experts and treating physicians, as we all know, are cornerstones to personal injury claims. And so the clients have to be reminded from day one to treat all the medical professionals, including the defense experts, with respect and civility, even though they're frustrated with the process. They often feel like their integrity is being impugned, particularly at trial when you sit there and you hear what a defense doctor has to say. You can imagine how upsetting it can be to plaintiffs. I had a trial in Victorville a few years back where my client was extremely unlikable. And so we didn't sit her, probably should have left her out of the entire trial and just had her come in and testify. But we sat her far enough back, sort of out of eye shot of the jurors in the audience section of that courtroom. And I was cross-examining the defense doctor on the stand. And about halfway through, the judge stopped me and he said, "Mr. Traut, I've got to stop this. Your client is gyrating, making faces, throwing her arms up in the air, in the back of the courtroom. The juror's seeing it. I'm seeing it. The doctor's seeing it. This has to stop." So, of course, I had to go outside, talk to her, very embarrassing for all of us, and tell her to knock it off and just let me deal with the cross-examination of the doctor. I didn't need her help. So it's super important that they treat all the doctors with respect. You should always have an observer go to a defense medical exam. There are some great ones out there. I have about 4 or 5 that I've used over the years. I don't have any complaints about any of them. They're usually either registered nurses or chiropractors who do this for a living. And essentially you have them there to take notes, to time it, to tell you what examination methods were used, which ones were not used, which should have been used. But also an important part of having an observer there is to have your client meet with the observer beforehand. I actually went to a defense medical exam last week because I know the defense doctor and I feel like I'll get a more fair shake if I'm there face to face with him. I've used him in cases before, and I think it will make a difference in the end that I was there. But most of the time, I have an observer go who will meet with the client a half hour ahead of time. And one of them is to control their conduct because you have to let the client know that this doctor is likely going to be minimizing your complaints and your care and your treatment and trying to reduce the amount that the carrier has to pay out at the end of the case. That's their role. They'll object to that as their role, but that's really what it is. So you need to have someone there, meet with them at least a half hour beforehand to give them the temperature of the room and what it's going to be like, and that the doctor, you want the client to interact with the doctor in a cordial and nice way. Obviously, you've talked to them about what they can say and not say pursuant to the code, but their conduct is important because I have seen defense medical reports where they'll talk about how awful the plaintiff was and objected to this, objected to that. And then when they're on the stand, if they're a halfway decent witness, they'll bring that up in front of the jury. And it sometimes doesn't bode well for your client. As jurors, they'll listen to the doctor and go, hey, client wasn't very nice to this doctor. So it's very important. Have an observer there, have the observer meet with the client beforehand. All right, let's talk about the next area, civility in the courtroom. So we've seen a lot of incivility in recent times about our judiciary, about the justice system. We've heard about attacks on the Seventh Amendment and our jury system. I'm on a committee with ABOTA called Save Our Juries. And I've had the opportunity to see statistical studies, surveys, federal court studies, the National Center for State Court Studies that prove how our jury system is dying, meaning that there are less and less, particularly in federal court. And there's a lot of reasons for it, but in recent times, it's been about the attack from our executive branch on our judiciary, on our judges, trying to control what they do, attacking them personally, creating an environment where others are attacking judges and their families at their homes. It's a serious, serious problem. And so I feel it's incumbent on us as lawyers who try cases in courtrooms, no matter what kind of case that you're trying, that on a grassroots level, we want jurors to appreciate and like the system because currently they're hearing so much bad about it. And as you probably know and have heard, one of the most tapped into resources on Google when somebody gets their jury service subpoena or notice are the websites that tell you how to get out of jury service. You have a lot more Google hits on what is than what is jury service like, or what does the Seventh Amendment mean to our democracy. And so it's disturbing. And so I feel it's incumbent on us that when we walk in a courtroom that we act and our clients act and our witnesses act with civility and professionalism. Because jurors walk into that courtroom thinking that the lawyers are going to be at each other's throats. There's going to be name calling. I mean, we've all seen shows from LA Law to Boston Legal to Ally McBeal, The Lincoln Lawyer. There's another one. The list goes on of dramas where people think, hey, maybe this is how it goes, particularly those who have not served as a juror before or been in a courtroom before. And so they think there's going to be this high drama and expect it. And we already, as lawyers, walk into the courtroom as one of the least liked people or professions on the planet. So we got a couple strikes against us now. So it's so important that we walk in the courtroom with a client who's civil, who spends time out in the hallway being civil. That's the other thing you need to remind them is if they're out in the hallway, the jurors are watching every move that they make. The jurors are, if they're within earshot, they're listening to you. And to not talk about the case and not spend time trying to talk to jurors. There was a just last week out in Fullerton Court. A defense lawyer friend of mine was telling me about a mistrial that she had because the plaintiff showed up to the courthouse, ended up talking to two jurors out in the hallway, talked about how one of her sons has a horrible disability. I mean, just stuff she should not have been talking about at all. I mean, at least it could have been, what do you know, it's a nice day, or really light comments that probably would not have resulted in a mistrial. But this resulted in 3 days of wasted time and probably sanctions against the plaintiff lawyer. So remind your clients to conduct themselves civilly. Don't get angry. Don't get sarcastic out in front of jurors, because they're watching. And even if you don't think they're watching, if you're in the cafeteria or the hallway or walking down the stairs or in an elevator, there may be a juror there, and they have to be extremely careful. But once you get into that courtroom, I let them know you treat everybody with respect, whether it's the defense lawyer, whether it's the court clerk, the courtroom attendant, the judge. The jurors are all watching. And again, we want jurors to come back. We want them to like the system, because they're hearing so much grumbling out there right now about, well, this system's rigged. And we know it's not. Those of us who are in trying cases, this is not. This is a group of folks with different life experiences, different people all coming to the courtroom to decide either a monetary or other fate of this litigant. And it's the best process on the planet. So we need to help preserve it. And civility is a big way to do that. The last case that I tried in January, which was my first medical malpractice case I've ever tried, and as those of you who are on this call probably know, they're very difficult cases. But the defense lawyer was so civil, so professional, I didn't have to worry about him trying any tricks, that in my closing argument, I gave him kudos in front of the jury. There's nothing wrong with doing that. Saying this lawyer, and I said, he's not in a BOTA, but if he asked me to recommend his application for his chapter in LA, I'd do it in a heartbeat, because he respects the system. He did a good, zealous advocacy for his client, and I appreciated that. And so does the court, so does the court reporter, the clerk, and I hope all the jurors do. Just a little comment like that. It goes a long way. And you'll also find that when your client is civil and likable, whether they give them a lot of money or not, in my world, a lot of the jurors will stick around and talk, because they like your client, they like the lawyers and how they've conducted themselves. It's those caustic trials where there's a lot of incivility, sanctions being levied, all sorts of stuff, shenanigans going on, where those jurors run for the door as soon as they get out of there, because they figure one side's going to be mad at me. Maybe both, we don't know, but we want to get the heck out of here. And I found that when the process goes the way it should, no matter what the outcome is, you will have jurors stick around and want to talk to you about the experience. And I think it's important that you do that. And it's also important for your client, if they've lost the case or if they haven't gotten as much money as they want, they can hear what happened and what the jurors' process was, of how they came up with it. So very important. Some just logistical things about your client in trial that I think are helpful, that I've had happen over the years that were not helpful. One, we talked about: watch your facial expressions, eye rolls, whispering, handing me notes. I will tell them during jury selection to don't hand me notes or tug on my jacket if you have a particular problem with one juror or another, or you want me to ask a certain question. We'll have a break. You can talk to me about it then, but I don't want my client appearing to be so interested in this case that they're trying to run it. And that's the way some jurors will think about watching them handing me notes, pulling on my coat. So I tell them, don't do that. Just sit there. If something funny happens in the courtroom during jury selection or during the trial, it's okay to laugh. You don't have to sit there stone faced the whole time, but watch the eye rolls, facial expressions, and passing notes around. The other thing that I think is important is don't look at me before you answer the question. So you'll have witnesses on the stand at trial who are within eyeshot of you, of course. And whether it's they want validation or whether they're unsure they're giving the right answer, I've oftentimes had, and I don't limit it just to clients. I've had experts do the same thing, where uh, they'll look over at me as they're answering the question or at the end of the answer, and it looks like to the jury that they're taking cues from you, which is not good. Even if the jury likes it, you don't want them thinking that they're looking for assurances or looking to you to give them a good nod if they gave the right answer. So always tell your clients to don't look over at you when they're answering a question. Typically, a good cross-examining defense lawyer is going to move the podium away from the jury, and so that the witness is looking sort of away from the jury across at the defense lawyer. But oftentimes you're right in that view as well, or you're close, and it's really hard unless you emphasize to the client to not do that. Don't keep looking over at me. And it's same thing during the trial. Don't try and be your own advocate by passing notes, frequently conferring with the lawyer in front of the jury, that sort of thing. The other thing that I think is important is that you recognize the fact if you have an unlikable client, you're going to have to own it. Some people are just not fixable, and I mean fixable from the standpoint of likability, hopefully credibility. You can fix a little bit, but even sometimes that's a problem. And so that case that I was telling you about in Victorville, where I had the client who was making faces and gestures with the defense attorney on the stand. The beginning of that trial was even more troubling, and I'll give you that story. This was one of those cases where I had not met the client other than in a phone call before trial, because on occasion during my career there have been cases where a lawyer who doesn't try cases contacts me right before trial and says, "Hey, can you try this case?" This was one of those, and I've never made the mistake again of not meeting with the client first. I think you have to do that. And now that we have Zoom, we didn't have Zoom back then. I definitely would have met with her. She lived off of Highway 395, so she couldn't just come into my office in Santa Ana. So that was a problem. And I was brought into the case in the last couple of weeks, so it was just too difficult to meet with her beforehand. And unfortunately, the plaintiff lawyer who referred it to me didn't tell me the whole story about how unlikable that she was. And it didn't come across so much in her deposition testimony. She did okay with her testimony, but her demeanor was a different story. So I would tell you, make sure you meet with your clients, meet with them for quite a while, particularly before trial, because most people have not been in a courtroom and know how to conduct themselves and how to act. They're nervous. They're going to hear things that people on the stand poking holes in their case. It's a tough situation. You really have to counsel them on how to deal with it. And I did that on the phone with this client, but I showed up on the day of trial and I brought in a buddy of mine, Rob Gibson, some of you may know here in Orange County, and he's also tried over 100 trials. And I said, "Hey, Rob, I got this one out in Victorville. Here's the story. She's got a horrible leg fracture. Looks like a good liability case, and the trial's in a couple weeks." And he said, "Sure, let's do it." So we planned to meet the client at the Victorville courthouse that morning, about an hour and a half before trial starts. We haven't even started picking a jury yet. This is day one. So we walk in, we sit down. If anybody has ever been in that Victorville courthouse, it's mostly criminal cases. At that time, there was only maybe one civil courtroom, and a lot of drug issues, a lot of criminal drug dealers are out in the Victorville area that are getting prosecuted. It was just a tough crowd. So we go in, and I heard the client had blonde hair, and she sort of walked with a limp, and that was about all I knew. I didn't even have a picture of her. So we see this woman at the end of the hallway walk in, and she's got a sort of short, white, form-fitting dress, blonde hair, and high heels. And that's her, the woman who has a horrible leg injury, and who is there for her trial. So we walk up to her, I introduce myself, and I said, we need to go shoe shopping because you can't wear these. There's just no way that somebody's going to give you fair compensation if you're walking around in high heels, and it just doesn't look appropriate. So we got in the car. Rob and I went in the car. She stayed in the courthouse, and we went over to a Payless shoe store, the only place open that morning at 10 a.m., probably the only shoe store in Victorville. And we find these slip-ons with a big yellow flower at the tip. It might have even been a big yellow sunflower, but it was the best we could do in a hurry. We really had to get kind of moving. So we had the right size. We got them. We bring them back. And so I see Rob go down the hall to give her her shoes. And at this time, there's jurors showing up, I'm sure. And I see her open the box, and I'm getting my suitcase or my briefcase open and getting stuff out. And I see her take the shoes and throw them, yes, throw them back at Rob. And see her saying something to him. And of course, it was, I'm not wearing these, they're hideous. And so he comes back to me and he says, I can't do this trial with you. I could tell she's already a nightmare. She just threw her shoes at me. So this is where Counselor Eric had to step in. And now Rob's already the bad cop, so I had to be the good cop. So I grabbed the box and the shoes, and I went down and I took her outside because I figured there were jurors that were showing up outside this hallway of this courtroom. I took her out and, of course, expressed the importance of how she looks, how she acts, all of the things I just talked to all of you about on courtroom demeanor, knowing the whole time she's only half listening because she was so angry about how hideous the shoes were. And I talked her into wearing the slip-on flowery shoes. And so she puts them on, and we go into the court. We pick the jury. And as I said, I counseled her on how to conduct herself. She didn't pass me notes. We actually didn't seat her at counsel table anyway, so she'd have to run up if she wanted to pass me notes. And so really the only sort of inappropriate behavior was her in the courtroom, sitting in the back and making all these gestures when the defense doctor was on the stand. And she did okay on the stand, got a little angry and snippety with the defense attorney a few times. But the one thing that was very clear by the time that she was done testifying is that she was very unlikable. There was 14 jurors, so we had 12 and 2 alternates, court reporter, court clerk, judge, me, Rob, defense lawyer, who's now chomping at the bit, loving this, all realizing she is very unlikable. So in my closing argument, I would have looked foolish and I would have lost all credibility if I tried to give a flowery closing argument about this client and her likability and credibility. There is no way. I would have been laughed out of that courtroom. So I owned it. And I said right out of the chute, I forget the exact words because it's been a long time, but something like, I understand how unlikable that Miss So-and-so is. I get it. Look, I've been dealing with it. You've seen me for the last week and a half dealing with it. And I think I even told them I put her out of eye shot, rows back in this courtroom because I didn't really know what to expect. But she's legitimately hurt. She's clearly upset about it and angry about it. She can't help herself. I've tried to counsel her on how to conduct herself in front of all of you, but it's just not who she is. This is who she is. She's upset. She's not going to put up with a doctor minimizing her complaints on the stand. So I went through this for, I don't know, just a few minutes. And I can tell you I had nods of ascension. Everybody nodding. Probably even the judge was nodding. I didn't look over, but if you have that ever happen where you haven't been able to control the conduct of a client or just have lost you've lost the ability to get up and argue that they're a super deserving, wonderful human being, then you have to own it. And in this case, it actually worked. They gave her, I mean, I think they would have given her double. They gave her a six-figure amount, but they would have given her double had she been super likable and somebody they felt like, would use the money to help herself down the road. But they did give her a pretty decent amount, a lot more than the defense had offered. And I attribute that to owning the fact that she was not a good witness and not likable. I'll add one other little story that I think is important. It's not specifically directed at client conduct and civility in the courtroom, but it's conduct in the courtroom. And it was an experience I had in Riverside many years ago, and it was a very well respected at that time by the defense in particular. He was a defense accident reconstructionist who was on the stand. It was a case against the state of California, Caltrans roadway design case. And so I had Harry Creeper, they had this guy on the stand, and he talked really fast. And I remember during his deposition that he talked really fast, and the court reporter was kind of going crazy trying to keep up with him. And so again, on cross-examination, I have him on the stand, and he's trying to explain his answers and explain himself, even though I'm making a motion to strike as non-responsive. That judge would let him go on a little bit. And he was talking really fast because that's what happens when you get nervous or you want to get something out, blurt something out. And so the court reporter stopped him and said, "Sir, could you please slow down?" And this witness, who had testified many times in the past, here's what he did. He leaned into the microphone and in front of the jury, and he said, "How is this?" And then sat back. And you could have heard a pin drop. That was the end of his credibility. It was the end of the juror listening to anything that he had to say because he had just insulted and demeaned the court reporter for asking him a very simple and reasonable question to please slow down. And that was his response. So again, in addition to talking with your clients and prepping them for their deposition, prepping them for trial, it's also just as important to prepare your witnesses, even those who are seasoned witnesses and have testified in the courtroom, even more so if it's a treating doctor, because they're generally not familiar with the rules of the road and what the burden is, and they have to say with reasonable medical probability, and those are other prepping things. But you also have to talk about their demeanor and how important it is, and not to get sarcastic or snippety or try and be cute, which I've seen doctors often try and be. And most of the time, it's going to fall flat, and it's not going to help them and their credibility in the process. So in addition to the clients, boy, you better really prep those expert witnesses for deposition and, most importantly, for trial, because they're going to be up in front of those jurors, and they've just got to conduct themselves in a civil way. Another thing, just sort of the final area of prepping your client, is in reacting to a verdict. And if you want to get feedback, and this is the way I express it to them, if we want to find out whether it's a win or a loss, if we want to find out what the jurors were thinking, how they came up with their decision, and I say to the client, you're going to want to know that down the road, because people are going to ask you, what happened in that courtroom? Good or bad? What happened? How'd they come up with that? So it's nice to be able to have a juror 2, 3 stick around and want to talk to you. And so if the result is bad, don't guffaw, don't get angry, don't throw your hands up in the air, don't make any exclamatory comments, because that assures them running out the room. And the only way then of me ever getting any feedback is to track one of them down later and make a phone call. So when that verdict comes out, stoic, no matter how bad it might be. And same is true if it's a very good verdict. Don't be jubilant, jumping up and down and clapping, and I've never had a client do that, but the same is true. You don't want to rub it in the face of the defense lawyer and their client. I mean, you do, but you really don't want them to do that in front of that jury. So you have to counsel them on how to conduct themselves post verdict. And also, sometimes jurors, I found, are concerned about being confronted by the defendant or the plaintiff. And so I generally tell clients to sit on the bench near where I'm going to be talking to the jurors if it's right outside the courtroom. And at some point, if I feel like it's worth the client hearing one-on-one, or if there's a couple jurors that really liked your client and had some nice things to say, then at that point, it's okay. And I wave them over. So I prep them on that. I let them know I'm going to have you sit on the bench, not because I'm trying to hide anything about what the jurors are going to say, but it sometimes leaves them open to talk more freely if you're not standing right there, particularly if they have some criticisms about what you said or some area of testimony or some evidence that came in, and they don't want to make you feel bad if you're standing right there. So I generally have them hang out close by and just sit on the bench, and then wait. And sometimes I bring them over. All right, let's take a look at another slide here. These are just quotes that I sort of lived by, and these are quotes that I talk to clients about, because I think they're good ones, particularly that civility is not a sign of weakness. I would go as far as to say in my practice, it's also a sign of strength. And civility costs nothing and buys everything. So when you have that talk with the client about, look, you're not going to get your pound of flesh, and even if you get a great result in this case, it may not be justice to you because you would rather have your life back the way it was before you were seriously hurt. So you can't expect that this process is going to end in your perceived justice, because oftentimes it does not. It's not going to put you back into the position that you were. But one thing is true, and that is that this process can result in maximizing your compensation if you conduct yourself properly in all aspects, and making your life easier, even with all that you have to live through. That's the goal of a personal injury lawyer, is to maximize your recovery so that moving forward, that your life can be easier as you deal with the consequences of your injury. That's really it. So those are all the slides I have. I know that we have some, see some things in the chat. And if there's anybody with any questions, I think there's a way for you to send those to our moderator and I can answer those. I'd be happy to. You take a look in the chat and see if there's anything. Okay.
So Eric, I don't see any questions in the Q&A right now, but we did receive one via email.
Okay.
This one is asking, what language or framing do you find most effective when a client says they want a bulldog or a fighter?
Oh, good question. Sure. So what I tell them first and foremost is that because I've been doing this now for 35 years, and seeing those lawyers who act out how their client wants them to act out as bulldogs or as attack dogs, whatever you want to call it, that is not an effective way to maximize your recovery. And the reason is it can often make that person unlikable, whether it's in front of a judge or a jury. You don't want to reward somebody who's acting out and not treating people with respect. And that I can make all of the same arguments I otherwise would as an attack dog, but do them in a civil way and in a convincing way. And I will explain to them that acting with civility oftentimes causes the listener to listen more, and for you as the lawyer to be more persuasive, because lashing out and anger are things that people generally just in our day-to-day lives we push back on, and we may shut down, we may not want to hear that person who's acting out. So I tell them it's important, the civility side of things, because you're going to ultimately, my plan here is to be more persuasive than the person opposite us. I want to be persuasive with the claims representative just as much as I do with the defense lawyer to try and get the case settled. And when we're talking about trial motions or motions for summary judgment, civility is really key. There's nothing more that a judge hates more than is a lawyer who's attacking someone either live in the courtroom or in their papers. There's nothing more. It doesn't help. It's with winning that case, it makes you less persuasive. It makes judges think less of you. And so if you want a strong relationship with the judiciary in the county in which you practice, you do it with civility, and you're going to go a long way to be persuasive in every aspect of your case. And I can tell you, I've never had, it doesn't happen a lot. I mean, literally once every couple of years, I'll have somebody come in who, Zoom with me or come in the office who says, I really want you to be an attack dog and I want a pound of flesh. I have never had anyone, after I explain those things to them, say, okay, I don't like what you just said. I still want the attack dog. Thank you for your time, and leave. Never. It's never happened. They understand it. They think about it. And it must be persuasive because I've never had anybody walk away from that. I also will counsel people who call me. I know all of us will get calls for referrals to lawyers in other disciplines. And I often get that phone call, particularly in family law, where I'll have a former client call me and say, hey, I'm going through this ugly divorce or child custody thing, and I really need a bulldog here. And I'll spend a few minutes telling them that that is not the way to go. Same thing in a family law setting. You don't want the incivility that can come from a bulldog in front of that court, particularly with not having a jury trial. And so I know from my family law lawyers that I refer cases to, they are the epitome of civility, and they treat the judge and the court and opposing counsel with respect. Those are the only folks I'll refer those cases to. So I try and talk that person on the phone out of the bulldog lawyer who's not even hiring me, and explain to them why.
All right, and then the next question from one of our attendees is, when do you decide to withdraw from a matter when the client is being abusive to their counsel, or do you have a list of suggested steps to take before moving to withdraw?
Sure. So I've only had that happen. I've made a motion to withdraw in 35 years, maybe 4 or 5 times. The last time was over 10 years ago. And it was a client who was demanding that I send certain discovery, that I ask certain questions at depositions that were just inappropriate. I think part of it had to do with the defendant's assets. It wasn't a punitive damages case. It was just things that were over the top. And I had a really good offer on the table, wouldn't consider it. So I just knew I was not going to be trying that case. And the client did not do well at the deposition. I was that far down the road. So I brought the client in, said, look, seems to be we're not on the same page here, and you're not going to get there. So you're going to need to find new counsel. And of course, wouldn't sign a substitution. So I had to do a motion, and the court granted it. But it doesn't happen very often. Usually I can talk them off the ledge. And get some consideration from them to let me do my job. I often give them the analogy of a plumber, and I tell them, look, if I had a leaky pipe in my wall at my house and I tried to fix it, my house would be completely flooded within an hour, completely. So I want the plumber who's been doing this 10, 20, 30 years, day in and day out, to do my plumbing. Well, you hired me to handle your case and do the best that I could for you. And by the way, I make more money if I get you more money. So why wouldn't that be my incentive on top of everything else? So it's really hard for them then to make that argument that my idea is better than yours, or I'm going to do this my way. That it does happen occasionally, but I don't see it often. And the courts are going to let you out of that case without any problem. Obviously, you can't set forth everything in a declaration that your client's doing, so the defense has it, but you can give them an inkling of it and get out of that case, just not close to trial. You got to be careful to do that soon enough.
All right, I believe that about wraps up Q&A.
Great. Hopefully gave you all some good food for thought, and I appreciate you, all of those who attended today. And if you had any other questions, feel free to call me or email me. I'm happy to answer them.